Hello, everyone. My name is Gene Quinn. Thank you for joining us here today. We're going to have a conversation about patent prosecution in the real world, the impact of generative AI on patent practice, both today and with an eye towards what's going to be expected moving forward into 2026. So, thank you for joining us. Um, we're going to take your questions. We encourage your questions, and we'll get to as many of your questions as we possibly can. We have a presentation prepared for you, but before we dive into that, let me turn it over to Renee and have her introduce the speakers. Renee, if you'll take it away.
Thanks, Jean. So, on our panel today, we have Elizabeth Shipsides. She's a patent attorney and founder of the Bazille Group. With a background in chemical engineering and experience as a former USPTO patent examiner, she brings both deep technical insight and practical legal expertise to her work. Elizabeth has spent more than a decade drafting patents, advising clients across a wide range of technologies, and integrating AI tools to streamline high quality IP protection. She's a forward thinking practitioner and a trusted partner to innovators. Next, we have John Lawrence. He's of counsel at Cole Freeman and Malone, where his practice spans the full spectrum of intellectual property, patents, trademarks, copyrights, and trade secrets. With engineering roots in broadcast and post-production technology, he brings hands-on technical experience to his extensive work developing patent portfolios across software, AI, communications, semiconductors, medical devices, and more. He also handles trademark worldwide and advises clients on monetizing their IP assets. Next, we have Samir Rayani. He is the CEO of IPAuthor, where he leads the company's development of cutting edge AI tools that transforms how patent professionals draft applications. With a strong background in technology leadership and executive roles across multiple software driven companies, he has guided IPAuthor through a significant growth while shaping advanced solutions for law firms and corporate IP teams. His vision sits at the intersection of innovation, technology, and practical IP needs. And our moderator today is Gene Quinn. He's a patent attorney and a longtime thought leader in the IP world. He launched IPWatchdog in 1999, and it has grown into one of the most trusted voices in patent law and innovation policy. Gene is widely recognized for his experience and expertise in software patentability and U.S. patent procedure, and he's been repeatedly honored as one of the top influencers and strategists in the global IP community. I also wanted to let you know that we have folks from IP Author that will be here to answer questions for you via the chat box. So you are in great hands today. Back to you, Gene.
Great. Thanks a lot, Renee. And as Renee said, if you have a question for her team, you need technical support, or you have a question, a very detailed question from the IP author, please put those into the chat. I'll monitor the Q&A box. If you have a question for the panel, please put it in there, and we'll get to as much as we possibly can. Before we go down the path of what we have prepared to talk to you about today, I always like to try and bring in the panelists on the front end here to give them an opportunity to say what it is that they came to say. In my experience, when somebody accepts an invitation to speak, they first check their calendar, and if everything is okay, and then they'll say, well, what would I say? What would I want to say? And that's what we're going to try and get to right now. Make sure everybody understands what it is that these folks have come here today to say. So, Elizabeth, maybe we can start with you from a big picture standpoint. When you're talking to other attorneys, inside your firm, your colleagues, your friends, and others about using AI for patent preparation and prosecution here as we get ready to flip the calendar. What do you tell them? Where do you think we're at? What's your big picture view on this?
In short, AI accelerates everything that leads up to the attorney judgment, but it doesn't replace the judgment itself.
Mhm. Yeah, no, I think that's definitely fair. We were talking about it, and that'll come up a little bit more, but we are not in jeopardy of losing our jobs. Certainly not yet, but we can do our job, I think, much better. Thanks, Elizabeth. John, your initial thoughts.
Well, I agree with Elizabeth. At this stage, I believe it's a tool like any other tool that we can use. But the beauty of it is that I think that over time we can help develop it into more of an integrated system. So it can become more of a tool. It can help us ensure the quality of our applications, help with the prosecution, and make sure we're covering all of our bases. It's another set of eyes that we could possibly use. And with them working together, all these tools, it could certainly benefit us over time.
Excellent. Great. Thanks, John. And Samir, your initial thoughts here today.
I'm just super excited about 2026. We believe that AI has become a credible player, a tool, as John put it, in the tool suite of IP attorneys, patent agents, and we are really excited about how it is being adopted, how many interesting uses it's being put to. And we want to share as much of that as possible, as much of that excitement as possible. It's really exciting to be here with you, Gene. You've been a great supporter for us. And just one thing I'll throw in also, that we just raised our seed round last month. So we completed our seed round, and so we are on to more exciting growth opportunities in the coming year. So all of these things I want to convey on the webinar today.
That's great. That's great to hear, because I know that doing this from your end, it takes a lot of passion, a lot of love. It's not just business. You got to love doing this. And then of course it takes a lot of investment, because AI is it's a very powerful, but it is not cheap to develop. So congratulations on that.
Thank you.
And let me end. While you guys were speaking, I had the first poll question up there, and I can share the results. And this gives us an idea of who the audience is that we're speaking to. We have the biggest number of people are in the evaluation of tools phase. We have a small number planned to adopt in the next 12 months. A lot of people that are experimenting with it. We have and a small number, like maybe about 1 in 5 people here who are already using it. So it really runs the spectrum here on the audience. So with that in mind, maybe Samir, I'll turn it over to you, and we can go through some of the slides and some of the presentation you have, and then start the conversation.
Absolutely. Thank you for that information. That's very helpful to understand where everybody is. And that was kind of our assumption coming into as we prepared for this webinar, that there is a lot of interest, there's a lot of experimentation, there's a lot of momentum. And that's why this panel is exciting, because what we wanted to share with you is how exactly is the technology being used today, and that's what we want to convey. We also want to give you a little bit of a forward-looking view of where things are going and headed as well. So we've already gone through the introduction. Just wanted to summarize, everybody, we are all sometimes sitting in our own silos, doing our own thing. You may be doing patent prosecution, or you may be doing licensing, and you see that AI is being used in your work, but you're curious about what it's being used in elsewhere. So one thing I wanted to summarize here is where all we have seen AI being used, and we have seen AI being adopted. And in the patent practice, we are seeing AI being adopted in invention harvesting, search, patent drafting, office action response, even in invention creation process as well. Of course, in a way that does not make the AI the inventor, but to support the invention creation process. It's not something that IP author supports today, but that's something that we have seen people do. Also, in terms of we are seeing AI being used in claim charting, in evidence of use preparation, in classifying patents, in doing standard essentiality mapping, as well as in cost and portfolio management of your patent portfolio. So across the board, we see a wide range of use cases for AI today. In today's webinar, in today's discussion, we are going to focus on just invention harvesting, patent search, drafting, and office action response. But in general, AI is being used widely in other areas also. So what I want to do is I want to show a quick demo about how IP Author is, where IP Author is today, our tool. We're really excited to share this with you. many of you, the names I see in the list of attendees, you've already seen our earlier demos, what was available. IP Author has been in business for nearly 3 years now. So you've seen it evolve. It does everything from searching to patent drafting to office action response. What we wanted to show today is more of the newer capabilities that we have added to the tool. Obviously, some of that is sort of really early in terms of its adoption. Some of that has been now widely adopted by our user base, but I just want to show it to you in a quick video to start off. This video is a little bit cut off from the side because we wanted to focus on the core elements that we want to highlight here. So please don't worry about it's not a problem at your end. It's how we have recorded the video here. So I'm going to start here, and we're going to start basically highlighting some of the features one by one. So the way you start with IP Author is you provide your invention disclosure or any kind of document that you have, any inputs that you have. It could be a scientific paper somebody drafted, or it could be an idea somebody just came up with and jotted on a piece of paper as they came out of the shower, right? Like it could be anything that can be provided as the input. Once the input is provided, IP Author extracts the images and all the text organizes it so that everything is in one place. This is a powerful new capability that we have brought to the table, which is the whole invention harvesting step. We call it the intake form, right? Where once the invention information is provided, IP Author comes up with a set of questions. Now, if you are a patent attorney and working with your inventor, these questions you can use with your inventor to make sure that you have a complete clarification, you understand the invention in full detail. If you are, there are clients of ours, corporations, that are putting this capability right in front of their inventors. So their inventors are using these capabilities as well now, so that they can clarify what is the real invention, right? So that by the time the patent committee gets the invention, but by the time the patent attorney gets the invention, it is fully fleshed out. This is the search capability. So once you have, the invention is fleshed out, you can conduct a patent search. Here, the patent search explains the similarity and differences between the prior art and your invention. It also explains, where it's getting the information from, so that you know that this information is accurate and there's no hallucination going on in this case. So all of this information is provided as part of the patent search. We've also added support for non-patent literature search, and many other capabilities are being added on the search front continuously. So once the search is complete, you can use this same invention information to either create a US or a European style patent application. So now we are multi-jurisdictional, so you can create your European style patent application. We also support European patent office responses as well. So office actions in Europe are also being responded to using IP Author. So that's a very powerful capability. Basically you draft once and then you prosecute everywhere, right? So that is one of the capabilities. These are some of the ways in which you can interact with the AI. So when it drafts the claims, you can modify the claims by just chatting with it, right? Chatting with the system. Also, we have made it very easy for you to make changes across the board and to track the changes. So traditionally, this change tracking has been primarily done on Word documents, and it's kind of cumbersome, right? You may have 3 or 4 people making changes, et cetera, and you don't know what version was what. We have a really powerful engine running here behind the scenes to track your changes. And that has become a very big deal for our users, so that if you make a change here to a label, the changes cascade down across your patent application. Once you accept those changes, then now you know what version was related to what change. So you can go back to a previous version of your claim, and then you can get all the different history of all the different changes you had made across the patent application that were teed off from that version of the claims. So it's really powerful. beats your traditional practice of using Microsoft Word for tracking changes significantly, and it's just more modern, right? Like, so that is something that we've been able to incorporate in the platform in the last few months as well, since we were here before. So these are some of the other capabilities where you can personalize the writing. So, for example, you have your own style of writing the background. You can adopt that style. You have a style that has been provided to you by your client. You can incorporate that so that the information is customized for that particular client or that particular pattern that you prefer. This is the track changes functionality that I had mentioned. Once you make some change in your initial draft or in your claims, those changes cascade down, and then they are used elsewhere and they are tracked. New functionality, again, handling chemical structures and chemical structure related drafting, office action response, etc. So in this case, the user provided a particular invention that was an analgesic. Here, the AI is trying to clarify some of the elements of the substitutions, and the user is providing all of those explanations so that the AI can go ahead and draft the full patent application. As you can see, you can edit all these figures, all these chemical structures right inside IP authors, so you don't have to go and make any changes outside. Everything is integrated, everything is smooth. You can then make changes, make improvements across your claims, across your invention disclosure, across your draft, and all of these elements will be taken care of. Similarly, we have support for antibody sequences, gene sequences. So when you have a gene sequence, the AI first analyzes it, and then you can incorporate that information into your patent application, so that now all of those features are added to your claims. Those features are added to the description, etc. So you will see here that these elements are added to the patent claim automatically. Okay. So now we jump into the office action improvements that we have made. So the office action response, we have streamlined it considerably. So you start with your application number, and then what the AI does is looks at the application and all of the historical prosecution history for that particular office action and for that particular application. Takes all of that into account, and then it summarizes the documents. Also, it summarizes the rejections that the examiner has given. It can handle patent and non-patent literature. It can handle all of the standards that the examiner may have cited, all of that. So once that is done, you can see what exactly the examiner was saying. And then we have this powerful capability, which is the examiner interpretation. So here, as you can see, we have color-coded what the examiner is saying, right? Like, so if we find that the examiner cited art fully discloses a particular element, we color code it green. If it is not disclosed, we color code it pink, right? And if it is partially disclosed, it's gray. All of these details are available for you to understand. So you can see what all is in the patent application, and you can understand where it's coming from. The explanations are all given to you. So now from this, you get to decide how you want to proceed with the office action. But you don't have to do it on your own. You have support. For every set of rejections, you get a set of strategies that you can pick from. You can always add your own strategy, but you can basically pick a strategy that was designed by the AI, and you can just use it directly, or you can make changes to it, whichever way you choose, or you can provide your entirely new strategy to respond to this office action. Once you've selected the strategy, once you've finalized the strategy, the AI drafts the response for you. You can obviously continue to make changes to the to that draft. All of that is available to you. You can make modifications to your strategy. You can continue to amend claims, all of that. So this is all available, but everything is being done in a fairly streamlined fashion. As you can see, all the changes are being checked before they are incorporated into the patent application and so on and so forth. So I don't want to take this too far. There's lots of capabilities here, but wanted to just share some of the key highlights for you here. So to summarize, we support chemistry patents, sequence patents, standard essential patents. We have the capability. These are things that I did not show you today. We can auto classify patent portfolios. We can do invalidation, FTO, and EOU searches. All of these capabilities are available on the IP Author platform. So for those of you who have seen us present before, you can tell that we have made lots of changes. We have made lots of new capabilities available to you through the platform. So now we can jump into the use cases. Over to you, Gene.
Okay, excellent. So we do have a couple questions here that might be worth talking about before we get too far away, because they relate to what you were just showing. One of them is, how do you develop the prosecution strategies?
Yes, so the prosecution strategies are developed based on the inputs that were that you saw, right? So what the AI is doing is it's taking every single piece of prior art cited by the examiner, whether it's patent or non-patent literature. It's analyzing every single line in all of those pieces of prior art cited by the examiner in light of the claim elements, right? So for every claim element that the examiner is rejecting, it is looking at what is available in the prior art, right? And then doing the analysis that we showed, the color coding. The color coding is not just based on what the paragraphs examiner cited. It's also including everything else in the prior art cited by the examiner. So once that color coding is available, then what the AI does is then it goes through a set of steps, like, what are the most promising lines of response? And these promising lines of response have been developed through a wide range of analytics that we have run, through a lot of sort of AI processing based on past history of examiner behavior at the art unit level, as well as the typical patterns that are being resulting in the best outcomes for the applicants. So based on that historical data, the AI suggests the strategy. And you can see that these strategies, we also try to provide a diverse set of strategies, so that if your goal is just getting a patent granted, because your client just wants a patent to be granted, versus you want to stand your ground and you want your claim exactly as it is, you don't want to change a word of it, right? So it provides that whole gamut of capabilities, right? So yeah, that is sort of the long-winded answer.
Okay, no, that's fine. So let's bring in Elizabeth and John now to the conversation, and maybe before we go in any of the specific key use cases that we have here on the screen, I just open-ended microphone really for you to talk about what it was that Samir showed us, and what do you see there that you think deserves some more consideration from the practitioner's point of view? Is there something that you particularly like? Is it something that is particularly powerful? John, I see your head nodding, so I'll go to you first. What do you want to share with the audience?
Well, I would expand on the last question having to do with the office action responses and how you figure out which path you're taking. I would also emphasize the fact that you don't have to follow that strategy. I have looked through some of the responses that have come back on office actions, and I've looked at them and I said, well, that's not the way I think the client wants to go. I want to go. And you can modify their responses. You can put in, I want the claim. You can go through the whole thing, but you say, that's not the claim amendment I want. You can put in your claim amendment and it'll work backwards. Check that it's supported and update it. So it's important to remember that there is a not a feedback loop, but there is a way for you to customize to make sure you're not stuck with those responses. You're not stuck with that, with those amendments. If you have a certain way you want to go and you know your client's going that way, you can adjust these, either adjust the ones that it's suggesting, or you can put in a brand new one, or you can amend the claim at the end there and it'll update itself to go with that claim amendment. So it's important to remember that. And I think it's very important that, um, I think that's even more important because it's important to remember that while it seems like there's a box here that we have to follow, I think that the product is trying to make sure that that's not what happens. It's providing you the input to, I want you to change the spec. I don't like the way you're doing it. I want to include this. I want the claim amendment to be this. I know you came up with this, but I want the claim amendment to be this. And it provides you, it'll get better with time, I think, but it provides you the ability to make that input and to work backwards with you and update everything that goes along with it.
Mm-hmm. Great, great. Elizabeth, your thoughts at this stage?
I was thinking that AI definitely provides you with the options, brainstorming, but ultimately the attorney makes the judgment and the call on which argument or which amendment to use.
Mm.
So, going on to your next question, Gene, which where I think is has been most made the most impact in my practice. I think that AI has definitely helped me cut across the blank page when I'm drafting. It definitely helps with that. And for the color coding on the office actions, it definitely cuts through the cognitive load and I can see the whole situation in one glance.
Mm-hmm. Yeah. Yeah, one of the things that I like, and it kind of hits a number of these use cases really, and maybe it's most specifically on consistency, but it comes up, it kind of melds the specification together with the claims and with the revisions and all this is, I like the fact that when the tool is suggesting an amendment or suggesting a claim language in the first case, it points to you where does this actually have support? And because one of the things that I hear over, and nobody's asked this question here yet, but over and over again, is about hallucinating. And we hear all the fears really with respect to more of the generally trained general AI. And I one don't think that there's nearly as much hallucinating when you have a very specifically trained tool like we have here in a vertical where it's a niche really, right? So it's been trained on things in this niche and it's just not, I just don't see it hallucinate as much, but that doesn't mean that you don't need to check it. You of course need to check it and have the ability to see that there and have it put juxtaposed next to each other, because invariably what will wind up happening is you think you've got the support in the specification for what you want to put in the claim, and then maybe it's not there or vice versa. So have you guys, either Elizabeth or John, have you used that feature, and do you have any war stories to share?
Well, I used, I'm sorry, Elizabeth, go ahead.
No, you go ahead.
No, I certainly use the office action response. Just as Elizabeth mentioned, the color coding is a fantastic way to initially get yourself hit the ground running. Because while I'm worried about hallucination, that's probably going to be more in the drafting stage. It's kind of hard here to do that, but it also makes sure that the examiner is interpreting the office action, the cited art correctly as well. That he's not hallucinating. That's referencing my element. So it provides a good back and forth. He immediately hits the ground running. Okay, I know what I see what he's going. I see the whether it's there. I see the where it is in the cited art. I can go right to it and read it myself and make sure that in context it does read upon my claim. And that is rather than what's the alternative? I have to sit down. I have to read again. I have to read the application again to get myself back up to speed. I have to read all the prior art. Then I see the office action. I see where he's referring to. This helps put that all in perspective and then much faster and then make sure that I'm not missing anything as well. So it's very, very efficient that way.
Yeah. Yeah, no doubt. And I don't even know whether hallucinating is the right term to be using in what I was just talking. It's probably not, right? Because one of the problems that we have as patent practitioners is, and what I was just describing is, I think I have it in there. I am pretty sure it's in there. I'm going to write a claim for it, or I'm going to amend the claim. And then you wind up, and it's your hallucination that it's not there, or it's not there as cleanly or clearly as I wanted it to be, or I needed it to be. And, and that's why I think some of these examiner insights I think are useful. Now, Samir, let me ask you, you can use these tools, like you could draft this up and then use those tools to kind of help identify where there may be problems in what you've drafted in the first instance, right?
Yeah, yeah, absolutely. So, you know, these tools are now quite powerful, right? Like we've come a long way in the last year or so since the models have become much better and so on. So, when you're drafting, for example, you can ask questions, right? Like, oh, this definition, am I doing it right? Like, am I defining it tightly enough? Or is there enough spec support for this particular claim? Or, in the future, can I create a continuation, using this additional matter that I've added to the specification? And you can just clarify all of those aspects when you're drafting, when you're preparing the patent application. On the office action response side, also similarly, right? Like we briefly touched upon it in the demo, but when you made a change, like, hey, let's merge claims 1 and 2, or you made some change, you made an amendment, you say, can you check the amendment, right? And it'll go ahead and check the amendment across all the cited art by the examiner and so on, just to make sure that you're not sort of trying to solve one problem and creating another problem for yourself, right? So that is something that the process automatically does for you. So you're not, I mean, again, as Liz mentioned, you kind of like keep trying to keep your cognitive load down, right? Like all that work that you had in your checklist, like, did I do this? Did I do this? Did I do this? All those things are being taken care of for you, which means that you are now focusing purely on strategy, right? Purely on getting your work done, and really responding to the examiner and really working with your client and your inventor, without having to worry about all those checklisty type of things.
Yeah. Yeah. So, well, let's talk about. Well, actually, Elizabeth, let me go to you because I don't think I gave you an opportunity to comment in that last go round. So,
Oh, you talking about written support.
well,
I would,
yeah, I mean, whatever it is you want to talk about there about how you find the using these tools that are available helpful for you because is it well, let me ask you this because maybe this kind of pivots us a little bit moving forward. Where do you think it provides the biggest bang for the buck?
I think definitely giving you helping you get through to the beyond the blank page. I
Mhm.
For drafting and also for um, the the office action and color coding, and also helps me strengthen the spec as well. I have uploaded an inventor transcript, and AI will flag the details or future directions that I probably should expand in the spec. And it also is pretty good at giving me additional dependent claim angles, and so I can build a stronger family without reinventing the wheel. That kind of touches on what I was going to add about the written support. I've noticed that the AI, um, it provides, instead, how we look for support, sometimes we do a keyword search in the application to look for support, but I think AI is, because of the knowledge and its context, it can actually look for more information that's relevant to the feature you're trying to add. So I think in some ways it can give you better or different, wider, diverse scopes, claim scopes. So I think it's, even though keyword searching is quick, I don't think it's necessarily thorough or comprehensive.
Hmm. Okay.
I would add that I save a lot of time. I think it can pay for itself by taking care of some of the mundane things and making those faster. Certainly, often we all have to submit, office action assessments before the client agrees to it. This is a very fast way to hit the ground running to create that. What am I going to edit? What is the idea? What's a good thing to create that? And the claim generation gets you past, as Elizabeth said, gets you past that blank page quickly. Certainly, you'll have to modify it. You'll discuss it with the client. You'll amend it, but it certainly gets you past that blank page much faster and makes it more economical.
Yeah.
And
Go
another
ahead.
thing is that I've seen that is extremely tedious is like coming up with labels, the text labels for the drawings. And Samir showed you can actually edit those drawings, but it gives you default labels. So, hey, there's something that I can call it. Sometimes I'm not sure what to call that element. So that also helps.
Hmm. Yeah. Yeah. So we do have a question. Maybe we can kick this around here for a minute about whether or not um, the use of AI systems by both the applicants on the outside and then the office on the inside will affect the number of 102 and 103 rejections, either, I guess moving into the future here. I I personally think it will. I mean, I think it's kind of have to, because if everybody, well, I think these AI searches that go along with the tool set are getting better and better and better and better, and I don't even know how much better that they can get because they're already finding an awful lot. I suppose as more and more databases get integrated, they'll just continue to get more robust. But if everybody knows what the examiner is going to actually apply, then normally you can come to some kind of terms on, well, what if anything is allowable here. And as long as you have reasonable skill in drafting, you can find something that will be allowed. Now, the question becomes, is that going to be interesting enough for the client? But I think, well, one, we know that the office is experimenting with these tools, using them already to some extent, want to use them much more moving forward for a variety of reasons. So if you're not using them, you're going to be, I think, at a disadvantage. Um, what say you, John? I see you shaking your head, so I'll go to you first.
I mean, I certainly think initially that's true with 102 type projections. I
Mm,
think the examiners are using more AI tools to search, but when it comes down to generating the office action and to making the rejection, I think that it's going to be a little while before uh, 103 and 101 type rejections. I still think I don't think the system has the ability for it to come up with those type of arguments that are fully flushed out. I certainly think it affects 102, but that's the beauty of it. Now it's so much easier to do the search. I get a disclosure, a semantic a search. I just pop it in, as Elizabeth said, do the search. I can see what the references are. It gives me an analysis of what's disclosed, what's not, what's uncertain. And if I want to focus someplace else, I can amend the idea of what it thinks is novel and what it's looking for, and I can tell it to amend it and look for that and focus on that. And I think that's basically what the examiner is doing on the other side when it comes to 102. When it comes to 103, there's a lot of interpretations, just like you can't just, as Elizabeth said, you can't just do a keyword search sometimes because that's probably not enough. The examiner could be interpreting some other thing that has a totally different wording, but saying it's the same. And what kind of arguments are we going to make to get past that? So I think on the 102 side, yes. On the 101, 103 side, I think it's going to be a little more nuanced and it's going to take a little more time.
well, certainly the 103 is a lot more subjective, right? So I guess reasonable
Yes.
minds could differ. Um, Elizabeth, what are your thoughts there? Anything else to say there?
Well, I definitely don't disagree with John, but I wanted to share my experience with
Sure.
101 where I asked the AI, can you look at my claims? Can you look at my spec? Do you think you'll overcome the 101 scrutiny? And it says, no, you need more information. So I go back and I put more information in it. I keep on doing it and doing it. And finally it says, yeah, now you have a good spec to, it'll overcome 101 scrutiny. I think it actually helps to flesh out the issues and the details. Um, especially the technical aspects, and you can go back to the inventor and they also agree or disagree, or you can ask them, hey, we want to meet the 101 hurdle, and the AI suggested that do you have this type of information? And they come back and they say yes, and you add it to the spec. I think AI will definitely help write more robust specs for 101. So that's my take on 101.
Yeah, no, and that's interesting too. And I also think it'll help you with some client. I mean, one of the dynamics, and there's probably a psychology PhD study in here somewhere, but in my experience, oftentimes your clients they won't trust you. You say, no, we need more information. No, I need this use case. I need whatever it is that you need. And they're like, well, why do you need that? Why? And maybe it's just they're familiar with you and they feel comfortable pushing back. And so they do. But then if you have some kind of objective analysis and say, look, no, this is not me questioning you or what you've given me or your invention, but this is, this is what the tool says. The tool says this is not enough. And looking at the case law as I know it and what we have here and what the feedback from the tool, I would agree. So we need to add more. I think that objective input can really be helpful. Before we have too much more time slip away, there's one thing on this slide that I specifically want to get to, and it's the drafting of U.S. and EU claims and converting them and foreign claims into U.S. claims and that sort of thing. How is that treated in the tool, and can you speak to that functionality a little bit? Maybe Samir, maybe we start with you first. So tell us what the tool actually does on that end, and then we'll get the panel to weigh in.
Yeah, so the tool basically it can generate claims and respond to office actions both on the US side and European side as well. So you say, okay, this is my invention disclosure, give me US claims, it'll give US claims. If you say give me EP style claims, it'll give you EP style claims and disclosure and so on. But this use case specifically comes from John, so I'll let John tell you about it. It's quite interesting. So John, over to you.
Oh, about the thing we talked about. Well, I just gave Samir one example. The last thing I used it, I was saying I received a request to file a national phase off of a PCT application and to give them a quote. I look at the PCT application and it's got 95 claims, and the claim 94 through whatever says every claim above plus. So it's multi-dependent upon multi-dependent upon multi-dependent upon multi-dependent upon multi-dependent. And what am I supposed to do? And how am I supposed to quote that? How can I get started easily without, having done anything at all? And it came to my mind. I just loaded the PCT along with the multi-dependent claims into the tool and told it to generate U.S. claims. It gave me a standard set of U.S. claims based upon that disclosure. They weren't going to be, objected to. Of course, now I have to go back to the client and say, if we were going to do a preliminary amendment, which we need to do, here is an example or a basis for it. Of course, you need to tell me if we need to adjust this because you are focusing on one thing or the other, or we wait later. But it's a great way to hit the ground running without providing, again, a blank page to the client saying to them, all your claims are going to be objected to. And it's just a much easier and faster way without sitting down for hours reading and generating a whole set of claims by hand.
Yeah. Yeah, because that's just a lot of form, and it's a nightmare. And that may be a great way to file a provisional application to make sure you've got claim coverage for everything, having multiple dependent on multiple dependent on. And I know there are some companies that follow that strategy specifically so that you don't wind up in Europe. Various jurisdictions in Europe will say, oh, well, the claim wasn't there when you filed it, so therefore I'm not going to let you have it, even though it's clearly in your disclosure, which that's going to be a foreign concept for us in the U.S. But in other places, they're just they take the no patent for you very seriously, I suppose. Kind of a tongue-in-cheek way to say it. But so you have to, when in Rome, you got to do that. So that can be a good way to very quickly, but then dissecting that, reverse engineering that when you need to is not easy. Just tedious. And that's the type of thing that these tools are really good for, is the tedious, and it does save time. And that actually maybe is a good pivot to the poll question I wanted to get to, and I'll launch this poll question, and I'll ask you guys to comment maybe before you see the answers that people have here about time savings, and what level of time savings would you ideally like AI to generate for your drafting and office action response. So maybe I'll ask you not what would you like to see, because I know Elizabeth and John, you're using the tool, but what do you see? Elizabeth, I'll go to you first. What kind of time savings are you experiencing? And if it differs between drafting versus office actions versus claim, feel free to, elaborate.
Well, time savings is definitely on the drafting side. It's able to spit out a detailed description pretty quickly. And I mostly trust AI with the summary of the invention. And so it's pretty good at spitting out text, and all I have to do is review it. Time saving wise, I think it's about 20 to 30% faster on the drafting side. And that's really great because it it gives me the time that I want to think more about strategy. But for the office action side, I think AI is really good at finding differences that I can either amend it into the independent claim or argue. So I would think that actually that's probably a little faster, because sometimes I read these references and they're really, really long, and it's hard to figure out to find that difference. And I think AI is really good at detecting these differences.
Yeah. Yeah, that's the type of thing it does very, very well, is summarizing things, identifying what's missing, what's not there, what is there that maybe you don't want there, and that kind of comparison stuff. It's really very good at. John, any thoughts from you on how much time you see yourself saving?
Well, on the drafting side, I'm not yet at the stage where, and I admit this, I think it's going to come, where I can just totally trust the output. I am maybe it's because I'm whatever structured, I like to work in a very structured manner. So I will draft by hand, but I will use the language that the system has generated for me. I'll pick and choose what I want, and I'll just keep going from there. I'm sure it's going to get to the point where you can start with the claims or you can start with the drawings, whichever one you wish. Iteratively, it'll work well, and it'll generate and then it'll pop out, and then I just have to proofread it. But I'm not at that stage yet. So I will say 20 to 30% faster on the drafting stage. On the office action response, I totally agree with Elizabeth. I mean, 30 to 50% easy, because it just makes the whole process easier. It allows me to focus as to where I want to focus. If I don't agree with what it's looking at, and I don't agree with its strategy, I can amend that and it can go back and check for me. And I can identify those sections. So it makes a huge difference there.
Yeah. So let me end the poll, and I'll share with you the responses, because responses the question asked in terms of, like percentage faster. And the largest percentage is looking for somewhere in the 30 to 50% faster. We have another group that are just not sure yet, probably because they don't know what is really feasible yet. And you will get faster over time. I can tell you that using AI, and not only will you get faster, you're going to get faster, and you're going to get better output and results coming back at you. But Samir, when you look at these numbers, is this about what you expected? Do you think people have a realistic expectation here?
I think it's really exciting, right? Like when we started the company about 2.5 years ago, and we would use these numbers that, this system can save you, 50 to 70% of time. When we did our previous webinars where, some of our users were initially already experiencing some significant time savings, like in some cases, 70 to 80% time savings. People would look at us completely incredulously, right? Like they'll be like, "You guys are smoking something." And now it's normal, right? Like now we are saying, yes, 50 to 70% savings we can expect, because everybody is using ChatGPT for drafting emails, for just reviewing contracts or whatever you're doing. And you feel that that same kind of impact should happen on your work. And it's absolutely reasonable. I think these numbers are completely reasonable, Gene, to answer your question.
Yeah.
Sure.
So we have the $64,000 question from the attorneys here is at what point will the client expect a 30 to 50% reduction in the cost? You know, and I know that companies are starting to kick around that if you're going to use AI and it's going to make you more efficient and save time, then they want savings. I mean, personally, I think that's foolish. I don't know how much lower we can go, just to be perfectly honest. You know, clients have wanted to pay 1980s rates, up until just even a few years ago, not saying not today, but even a few years ago, without any of these tools that made us faster, they just wanted us to do more and more and more and more, with no care about inflation, no care about inflation of not just dollars, but inflation of what needs to go into the application to satisfy this federal circuit. And clients need to, I think, be realistic, because if you're going to expect to pay 30 to 50% less, then what's going to happen is the same thing that happens every time you pay less. You're going to get less. It's not like you're going to say, attorney, I want to pay 50% less. And the attorney's going to say, okay, well, I'll just won't sleep. I'll sleep an hour a night so I can deliver you the same amount of work for less money. So I have to get twice the amount of work. It's just not how this works. I mean, that's just not real. It's not realistic. So we'll see where things go with that. I think, yeah, can there be some efficiencies? Can there be some savings that clients get? Yes, but I think from the client perspective, what they ought to really want, if they want to get patents that matter, and some people just want to get numbers, I understand that, but if you want to get patents that matter, these tools are going to make your attorneys so much better, so much, like as I think it was Elizabeth said, these tools, they do allow you to develop a much more robust specification. I mean, and this is not a zero-sum game here. This is where the target we have in mind is the protection of an invention, and the Federal Circuit increasingly wants more and more and more in these applications. So I guess I'm just get off my soapbox at the moment. If anybody who has any comment on that, I don't think it's unrealistic to clients to ask for some savings, but they've been squeezing us like a rock for a very long time. Any thoughts,
I would
anyone?
say,
Or
Oh,
go ahead, Elizabeth?
I would say that
Or
the 30 to 50%. Okay, that's has to do with how quickly we can get things done. It's got nothing to do with the benefits that we bring to the table. Making sure that the clients, a goal is achieved in the way they want it achieved. That they understand the process. That we're keeping to the formalities. That we're not getting one-on-one rejections right away. That the client understands that we're asking you the right questions, as it goes to Elizabeth said about the 101, that I'm asking you the right questions so I can fill in the application with as much information as I can to give me as much ammunition so that we can get past all these rejections and get it done as quickly as possible. That's got nothing to do with the ability of the system to make that easier for me. What I think the system does is it provides a better structure, and it provides a second set of eyes and a backstop for us so that we can go back to the client and do what we do always, is provide them with the information. If they're cooperative, give us that other information back and produce, as Elizabeth said, a better spec for them to work off of. But that doesn't mean that it gets to be cheaper and cheaper and cheaper.
Right. So I don't know
very
whether we
well.
lost Samir, but we'll just
Oh,
carry on. Go ahead, Elizabeth.
I just said very well said, John. I just think that patent attorneys are perfectionists. So we might be using that other time to fill out other areas of the spec. Like the AI might be good at describing the drawings, or describing like a graph that was provided by the client. But then like if we're doing a chemical composition, we're going to think about other avenues of how we could put in extra potential patentable nuggets. Like we might develop the microstructure, or we might provide other properties or features and ask the client about it. I don't think I will just cede the time and just ask,
Right.
I will work my full hours and provide, it's ethical duty. I'm going to work those hours and provide the best spec I can.
Well, and that's correct, right? Because what we all know is that when the client is willing to pay X dollars, the project is not necessarily done to say even a 95% threshold within that amount of time. What happens is the client says, well, I'm willing to pay you this, so you do as much work as you can within that envelope. What we're talking about here is actually being able, I think, actually being able to deliver something where we get to the point where we really additional time is not going to make it any better. It might make it different, but it's not going to make it any better. And so that I think is the real. And will there be some cost savings? Probably, but I think that clients that are looking for cost savings here are missing the whole point of the power here. It's going to make your drafting, your office action strategy, your response much tighter and cleaner. And where it will save you money is by making everything better every step of the way. It's going to make for a much smoother prosecution. And let's just be honest, these long drawn out prosecutions with applications that are, may or may not have enough support or come from overseas and were written for a different purpose that's where expenses balloon because it just takes longer to prosecute them. You're filing RCEs, you're doing more office actions and all that. All that can get cut out. So there is that savings to be had. And you get a better asset. I think this is just win-win. Samir.
Gian, I just wanted to cover a couple of, since we are running out of time and we
Sure.
promised the audience that, we are going to talk about 2026 also. So I just wanted to briefly touch on that, if that's okay.
Sure, go ahead.
So, just wanted to kind of quickly summarize the types of things that we are hearing from our esteemed users like John, like Liz. Some of the top requirements, some of the top pain points from using AI, things like element-wise search, interactive disclosure Q&A, which we've already implemented to a great extent. Figure-based drafting, being able to, somebody asked on the Q&A also, how does it deal with really complex figures, structured off-section responses, user-defined formats, etc., examiner pattern analysis, those types of things. Trend tracking, that's something really important, right? John raised this issue that the patent office is changing its parameters under the new administration rapidly. Are we keeping up? Is the AI keeping up with those changes? And are these new office action responses taking that into account? And that's something that we want to make sure that the platform is able to do so that it can serve as a really, really great assistant and a sidekick for yourself. From our standpoint, some of the big things we are working on are making sure that the workflow is completely personalized to you. So you can ask the AI to do what exactly you want and become more responsive to your style, provide you more claim-centric intelligence across the board, like element-wise analysis, licensing, freedom to operate type of analysis. We want to integrate all of that. And then they just keep taking the global nature of prosecution into account, draft once, prosecute globally kind of a model as well. So these are all the capabilities we are adding in the coming years. And as an industry, we are all making tremendous progress. So just wanted to, share that as well.
Okay. Great. In the last minute or so that we have here, maybe we can ask our two panelists, John and Elizabeth, to give us your thoughts on what the future is going to hold here as we flip the calendar. And I'll just leave it at that. So it's open-ended, so you can take it in whichever direction you want to go in. Elizabeth, you first.
Well, my biggest takeaway is this. AI helps me think more clearly. It highlights the differences. It surfaces the structure. It reduces cognitive load. If you use it intentionally, you get both speed and quality, and the judgment still belongs to the attorney.
Okay, great. Awesome. Thanks, Elizabeth. John.
I think it's important to realize that all these tools are somewhat out there already in one form or another. We can all do searches. We can all use other models and whatnot to generate specs or whatever. The key is here that everything is integrated together. And I see in the future all these tools coming together. The way it works now is I can put in a semantic, disclosure from the inventor, no matter how loose it is. Not only can I then start get a claim out of it to start discussing with the inventor, I can do a search. I can tell the search, can you focus on this and focus on that? It can identify what's missing, what's not missing. It can generate questions for me, telling me, I'm missing this. You should expand on this. You can expand on that. All this is all done in one place, all integrating, all working together. And that is certainly something, as Elizabeth said, that can make the quality better and reduce time and allow you to spend more time on a strategy with the client.
Yeah. Excellent. Excellent. And Samir, I'll give you the final word.
Well, thank you again, Gene, for the opportunity for us to come together on this panel. This has been a lot of fun. We have, by the way, the sign up page, ipauthor.com/sign-up. So you can sign up for a trial for you to use IPAuthor. Coming to where we are and where we're going, Gene, to your question, I think that what we are seeing as as product developers, as inventors, is it's really gratifying that the technology is actually now being used on a day-to-day basis. It has become part of the practitioner's toolkit. And that's a great start. And it can only get better and better as we go forward. So this is going to continue to snowball this whole capability, and its impact is going to continue to snowball. People are using it in so many different ways. I've lost count of all the different ways in which the technology is having an impact. So we are really excited about the future, about 2026, and we hope to continue to share our excitement with you. And thank you again for the opportunity, Gene.
Awesome. Well, great. Well, thank you everybody for joining us here today. We appreciate you sticking with us as we flipped over by a couple minutes, but we hope you got a lot out of today's conversation. And I look forward to seeing you all at a future webinar, but that's all we have for today. Thank you, panel, and thank you all in the audience for joining us.
Thank you.